The Institute
for Justice.
The National Law Firm for Liberty.
Hello and welcome to Short Circuit, your usually bi-weekly podcast on the Federal Courts of Appeal. We've been swamped, but expect to record again regularly from here on out. Thanks for bearing with us. As always, I'm your host, John Ross. Today I'm joined by Evan Bernick and Robert Everett Johnson. This week on the show, a pair of Second Amendment cases, surveilling taxi drivers, and a call for the end of Chevron deference. Rob, kick us off.
So our first case today comes out of the Ninth Circuit, and it involves an individual who tried to purchase a firearm and was told that they couldn't because they hold a medical marijuana license from the state of Nevada. And curiously, this person says they don't actually smoke marijuana. They just hold this license as a political statement. But the gun dealer who they went to said that because they were licensed, they could not purchase a gun because there was a possibility that they might be an illegal drug user. And the Bureau of Alcohol, Tobacco, and Firearms has said that illegal drug users cannot own firearms.
Yeah, she brings a number of constitutional claims. The most prominent claim is a Second Amendment claim. She claims that insofar as the Constitution protects an individual right to bear arms, she cannot be deprived of that right absolutely on the basis of the fact that she is engaging in what is, in the state of Nevada, entirely lawful activity.
So where did the Ninth Circuit land, Rob?
So the Ninth Circuit basically says that they're not going to try and divide this up into the question of, is it lawful to ban gun ownership for people who hold lawful medical marijuana cards versus people who are habitual users of some of the most hardcore drugs on the planet. They basically say we're just going to lump together every hardcore drug user in the world and say, is there evidence that this prohibition on gun ownership by drug users is advancing a reasonable government end? And they say, well, there's statistical evidence that drug users as a whole are more likely to commit crimes. And so, they basically just say that they're going to uphold this without doing any real scrutiny into the individual facts of this case or this individual person.
But what's striking is that they acknowledge this. They acknowledge that the government is conflating people who are using medical marijuana with people who are unlawful drug users who may be involved in violent criminal activity. But the court really doesn't pursue that any further and applies a version of intermediate scrutiny that, as far as I can tell, is indistinguishable from rational basis review. They actually analogize the applicable standard here to the standard that's used to gauge whether you can stop somebody, whether a police officer can stop somebody on the street and pat them down under suspicion that they are armed and dangerous. I mean, this is a standard that is not empirically driven, that does not focus on the tailoring of means to ends at all. And yet, this is what the court calls intermediate scrutiny. I mean, simply put, that is not what intermediate scrutiny is. Intermediate scrutiny is consistent with what we call judicial engagement, which is an evidence-based, impartial, means-ends analysis. The court does not apply that at all here.
One of the most amazing things about this opinion is the use of statistical evidence. I mean, you just see the court basically saying, here are some studies that have been cited by the government that show that drug users as a whole are more likely to commit violent crimes. And apparently that is enough to deprive you of your constitutional rights, at least for the Ninth Circuit and at least in the context of the Second Amendment.
And there's another consideration that's worth focusing on here because it is going to come up in the next case as well. And this is that the Supreme Court held in Heller that your right to bear arms in self-defense and keep weapons in your home for that purpose is a core right. There's no intermediate scrutiny. There's no compelling interest, heightened scrutiny in Heller. There's no level of scrutiny at all. If the government deprives you of your ability to bear arms in self-defense, and you are not, you don't fall within a number of exceptions that the Supreme Court recognizes, none of which are applicable here, you have a right to purchase a weapon. That is being denied. So in my opinion, we shouldn't even be doing a interest balancing means-ends analysis. It should be categorical. This woman should be able to purchase a weapon.
What are some of those exceptions, Evan?
So long-standing exceptions the Supreme Court kind of acknowledges are bans on possessions by felons, unusual or dangerous weapons, possession of weapons by the mentally ill. There's an entire list that appears at the end of Heller, and there's not really an effort to justify that list in any great detail. But they don't apply here. This is not a felon. This is not somebody who's mentally ill. This is not an unusual or dangerous weapon. This woman is simply trying to purchase any weapon, and she's being prevented from doing that.
Okay, well, then let's move on to the next case, which comes out of the Third Circuit. Evan?
Yeah, so this case involves two men who are bringing what's called an as-applied challenge to a federal law that generally prohibits felons, people who have been convicted of crimes for which the punishment is more than 1 year, from possessing weapons. The individuals in question were convicted under state law for crimes that are punishable for actually, in one case, up to 20 years. But the individuals in question don't actually spend that much time. One of them gets a suspended sentence, the other spends a short time in prison, and they have a clean record after that, and then they seek to purchase weapons.
And it's probably worth mentioning the specific things that they were convicted of. I mean, one of them was when he was convicted of being a 41-year-old man who had a relationship with a 17-year-old girl who was over the age of consent in his state. And the other was convicted of traveling with an unlicensed firearm, but it was a firearm that was legal for them to own. They just hadn't done the licensing paperwork, and that was 25 years ago that conviction happened.
Well,
right,
so
but
how can you get?
Sorry.
What's the? If she was over the age of consent, where's the crime?
He was convicted of a misdemeanor offense of corrupting a minor. But
Okay.
it wasn't statutory rape because she was over the age of consent. It's just a different offense.
Interesting.
I'm not an expert in that area.
Neither are any of us.
Regardless, federal law has an exception for individuals who are convicted of misdemeanors at the state level that don't carry punishments of more than 2 years, but that doesn't apply here. So these individuals want to purchase weapons. Federal law says that they can't, and the question is whether that is consistent with the Second Amendment. And what we have is a deeply fractured decision that ultimately concludes that, yes, these individuals can, in this as-applied challenge, purchase weapons. The Second Amendment does protect them, and the government's means to protecting public safety in this case don't justify the particular restrictions that it has put, given that these individuals are not dangerous and want to purchase weapons.
Rob, what does it mean that the decision is deeply fractured?
Yeah, so you have a kind of interesting lineup here where the actual opinion for the court is written by a combination of just 3 judges. This is an in-bank court, by the way. So the actual opinion for the court is written by just 3 judges. And then you have a 5-judge concurrence, and then I believe it's a 6-judge dissent. I may be counting them wrong, but you get the general idea. There actually are more judges concurring than there are writing the opinion for the court. But then the judges in dissent join the legal analysis of the concurrence on the standard, of the opinion for the court on the standard, which is why that becomes the opinion for the court. And this is, to put that in more in plain English, the weird thing that's going on here is that the judges in the dissent are basically joining with a small number of judges to set the legal standard in a way that is less protective of the Second Amendment, with more of the judges actually concurring on a ground that is more protective of the Second Amendment.
So the standard of scrutiny that's applied in this case is intermediate scrutiny. And as I mentioned in the discussion of the first case, this is generally consistent with judicial engagement. It's evidence-based. The government needs to show that the particular means that it's chosen are consistent with its ends, and it needs to justify that. And in this case, the federal government didn't even come close to doing this. It could not compellingly explain why these individuals should be unable to purchase weapons, even given its legitimate interest in protecting public safety. But what the concurrence points out is, and this is what I pointed out in the previous case, here you have individuals who are completely forbidden to purchase weapons. So the government's not regulating the exercise of Second Amendment rights. It is prohibiting these individuals from exercising them. And what the concurrence points out in this case is that although, yes, these people are felons and they were convicted of crimes that carry punishments up to 1 year imprisonment, the Supreme Court in Heller said that bans on felons owning weapons are presumptively constitutional, which contemplates that presumption could be rebutted. And the concurrence makes a powerful case, to my mind a compelling case, that as applied to these individuals, the presumption that bans on felons possessing weapons aren't justified. the bans on felons purchasing weapons that you find in the founding era and for a long time throughout constitutional history presumed that the individuals in question would thereafter be a danger to the public. These individuals have not been dangerous to the public. One of them actually is a contractor for the government. He has secret clearance. The other has completely changed his life. And they have made a persuasive case that that presumptive ban doesn't apply to them. Insofar as that's the case, the Second Amendment protects them, and the government should not be able to deprive them absolutely of exercising their rights.
Back to your comment about felons at the time of the founding, Evan. You mean that at the time of the founding, felons were typically convicted of dangerous crimes or violent crimes against people or property, whereas now we have more crimes, more felonies that have nothing to do with violence. Is that what you meant?
And those bans were always in connection with the concern that those individuals would thereafter be a danger to the public. So if we're creating a presumption of the constitutionality of a ban on felons owning weapons, those former felons who seek to own weapons should be able to demonstrate that the justifications for preventing felons from having weapons do not apply to them. And I think these individuals did that.
One of the interesting things that you see here in the dissent is basically making the same kind of analytical move that the Ninth Circuit made in the last decision that we were just talking about. So the dissent basically says, look, the government has put forward statistical evidence that people who have been convicted of crimes that are punishable by more than a year in jail are more likely to commit violent offenses in the future. And so the dissent basically says if you have the statistical evidence, it doesn't matter who you are or how you fit into that statistical group. You can just lump all those people together and you can treat them all the same, and that's totally fine.
Right. It would make an as-applied challenge entirely impossible. You could not demonstrate that you are the exception to a general rule on the basis of the fact that the statistical evidence that the government has marshaled that's very general doesn't actually apply to you at all.
And the majority and the concurrence do a very nice job of going through that statistical evidence and showing why it really just you can't generalize in that way when you're talking about people's constitutional rights. That you can't just lump everybody together and say, well, there was a study that treated them all as the same, so therefore they all are subject to the same kinds of constitutional treatment.
That said, I mean, despite the fact that, yes, you get judicial engagement in the context of intermediate scrutiny here, I think the differential application of intermediate scrutiny that you see in the Ninth Circuit and you see in the dissents in the Third Circuit case illustrates the perils of intermediate scrutiny. It can be very fluid, and in my opinion, because Heller stands for the proposition that an absolute ban of somebody who is protected by the Second Amendment of owning weapons is unconstitutional, that is the route to go, not even an engaged version of intermediate scrutiny.
Well, and just beyond that, too, I think the difference between these two decisions, both supposedly decided under the same intermediate scrutiny standard, just shows how the attitude of the judges and the way that they apply the law is often much more important than the actual doctrine that they're applying. And you can have two judges applying the same standard to basically the same kind of case. And just because they adopt a different attitude, they can come to completely different conclusions.
Yeah, that's actually true of all levels of scrutiny. You sometimes get engagement in what are nominally rational basis cases, and you get abdication in cases where you have strict scrutiny, where the government needs to show a compelling interest, a narrow tailoring. So the attitudes that judges bring, more than this framework or the doctrinal framework that they are actually applying, can do much more work.
Okay, well, let's step away from the Second Amendment now and move over to the Second Circuit. Rob?
Well, so this is a fun little case out of the Second Circuit. You have a cab driver who, back in 2004, the New York Cab Commissioner required all cabs to put GPS devices in their cars. Along with, I don't know if you've been in a cab in New York, there's the annoying TV screen that talks at you. And
that you can't turn off.
And you can't turn, well, you can, but it's very hard. And this TV screen is doing a number of things, but one of the things it's doing is it's a GPS tracker on the cab. So this cab driver and many other cab drivers were found to be routinely overcharging passengers by hitting a rate button to charge them a different rate that shouldn't have been applying. And the only way that this was determined was based on the GPS evidence. The Cab Commission tries to fine and otherwise penalize this cab driver. It goes up and down through administrative proceedings, and there's never able to make anything stick. But they're continually going after this guy. So finally, he files a federal case against the Cab Commission saying, all this GPS evidence that you collected against me was collected unlawfully because you put this GPS in my car without my permission, and that's a violation of the Fourth Amendment.
Right, and there's a lot of work that's being done with my car and my permission, because there's actually a substantial dispute between the majority and a judge who concurs and dissents from the opinion that we'll get into in a little bit about whether this car was actually this individual's private property. If the car was this individual's private property, then we have a case on point, it's called United States v. Jones, that says insofar as you have a physical trespass on that vehicle, and that physical trespass results in that individual being followed in the context of GPS tracking, then you have a Fourth Amendment search and it needs to be justified. The majority in this case comes to the conclusion, and we'll see whether this conclusion is actually pretty questionable, that because this individual is not able to establish that he has a property interest in this car, that case doesn't apply. And the concurrence/dissent takes issue with that and said the district court actually didn't determine that this wasn't this guy's car. They just assumed that because he's a taxi driver, that's somehow less private and there's an implied license for people to use it, and therefore somehow the Fourth Amendment doesn't apply.
How do you get a case this far? This is a federal appeals court, and we don't know if it's actually his car.
So this really actually goes to the difference between the majority here and the dissent. Because what the majority is saying, he didn't put forward any evidence that he owns this car, which might instead just be part of a fleet of taxicabs owned by somebody else. But what the dissent says is, nobody challenged that he owned the car, so he never had any occasion to do that. The dissent points to, all of these different 60 pages of briefing that were filed in the district court, and at most there's one line that anybody has said raised this issue. So it's very plausible that he didn't put in that evidence, or we don't know either way, because nobody thought it was important and no one made it an issue.
And regardless of that, if you actually look at the language from the district court's opinion, it really is troubling because it seems to presume that insofar as the public is using your vehicle or using your store or whatever, there is somehow a diminished Fourth Amendment interest as a consequence, to the point where this individual doesn't even get to allege that he has a Fourth Amendment interest because so many people use his car. That can't be right, nor can the notion that because you know that the government is regulating your property deprive you of your Fourth Amendment interests. So regardless of the underlying facts, I think that the concurrence/dissent has a good point with respect to the district court's reasoning.
Yeah, I don't read the majority here, though, as adopting the district court's reasoning. I think that it seems to me that the whole panel disagrees with the district court. This idea that somehow a cab becomes waives any Fourth Amendment rights just because people get in and out of the cab. I don't think anybody buys that.
Yeah, they just don't address it at all. To the extent that the district court is relying upon a theory which suggests that if the government is pervasively regulating your property and you're offering your property for people to use, therefore you don't have Fourth Amendment rights, the majority doesn't accept that line. The dissent explicitly rejects it, and there's just the district court which is taking that ultimately baseless position.
Okay, let's move on to the final case, which comes out of the 10th Circuit. Evan?
Yeah, so this case comes out of the 10th Circuit. It's a modest little immigration case that actually catalyzes a fascinating discussion of one of the most important doctrines in administrative law today. The case gets going because of a federal statute that gives the Attorney General discretion to allow people who have entered the country illegally to remain, to be lawfully present in the country. And that provision's conflict with another provision that essentially says that if you enter the country illegally, you've got to wait at least 10 years until you try to get in again.
So what we see are a series of back-and-forth decisions between the Board of Immigration Appeals, the agency decision-making body here, and then the 10th Circuit. So initially, the 10th Circuit says that the Attorney General retains discretion to allow people to stay, harmonizes the statutes that way. But then the Board of Immigration Appeals disagrees. They actually read the statute as taking away that discretion from the Attorney General. And then the question arises, what about cases that were decided or arose before the Board of Immigration Appeals essentially overruled the interpretation of the statute by the 10th Circuit? And the 10th Circuit initially says, well, it doesn't have retroactive application. It doesn't apply to cases that arose before the decision of the BIA. And then going forward, they actually say it also doesn't apply to cases, and this is what this case involves. The question is, does it apply to cases that arose after the decision of the BIA, but before that decision was essentially affirmed by the 10th Circuit? And what the 10th Circuit says in this case was, well, the BIA may be able to overrule 10th Circuit interpretations of statute, but if the agency does that, it only becomes effective and it only applies once that overruling has been recognized by a decision of the 10th Circuit.
Right, and the very complex nature of this back and forth prompts Judge Gorsuch, who writes the opinion in this case and then writes a concurring opinion in his own opinion for the courts, to really think about the central doctrines that allow an executive agency to effectively overrule a court's interpretation of a relevant statute, to essentially, there's no other way to describe it, to adjudicate, to interpret and expound the law in an authoritative way. And the central doctrines in this case, or the central doctrine, is known as Chevron deference. Chevron deference requires that insofar as an agency is interpreting a statute that it claims confers authority upon it, that interpretation should be deferred to by a reviewing court so long as the statutory language is ambiguous and the agency's interpretation of that language is reasonable. The long and short of it is that courts do not try to come to the most accurate understanding of the statutes. They defer to agencies' reasonable interpretations, even if they aren't the best. And as a consequence, executive agencies can essentially step into the shoes of judges and interpret and expound the law in an authoritative way and command deference from reviewing courts.
And when we talk about an agency overruling a court, I mean, what we're really talking about here is that you have a court that has interpreted the statute one way, and then the agency says, well, that's fine, that's one way you could interpret it, but we think it's ambiguous, so we're going to interpret it a different way. And then when it comes back, the court is actually required to defer to the agency. Even though the court has already interpreted it its own way, it now has to go the other way and follow the agency, which basically takes the function of interpreting statutes and it takes it away from the court and gives it to the agency. And there is just an incredibly obvious example where you see how the judicial function is really being undermined here by the doctrine of Chevron deference.
Right, and you have an incredible consolidation of executive power as a consequence. You have an open-ended statutes that effectively enables agencies to, the pretense is they're just filling in the blanks or they're just applying the statute, but in truth, they are making binding rules that bind individuals outside of the courts. Insofar as they're doing so, they are legislating. They are also, insofar as they are interpreting the applications of those statutes in particular cases, they are adjudicating. And they are also, of course, executing the law. So you have the consolidation of legislative, executive, and adjudicative authority in a single branch. And this is precisely what the separation of powers that's central to our constitutional system was designed to prevent, that kind of consolidation of historically dangerous power. And we have it here, and it's been facilitated, of all things, by the judiciary. Judge Gorsuch has had enough of it, and his concurrence is really worth reading, because he makes a powerful case that whatever Chevron may be, that has no mooring in either the APA itself, which seems to contemplate de novo non-deferential review, is inconsistent with the Constitution's allocation of power, and has made, frankly, a mess of the case before him, which is probably prompting him to engage in this discussion.
The point about the APA is a nice one. I mean, the way that Chevron deference has been framed by the Supreme Court is, well, if Congress writes an ambiguous statute, they've somehow deferred to but they've delegated to the agency through this ambiguity, the power to the agency to make law to clarify the ambiguity. And what Gorsuch says is there's no basis for anybody to think that Congress actually did that. I mean, we're just sort of making that up. And if
right.
you actually
Even if they could, they wouldn't be able to, but we don't have any reason to think that they could.
Right,
and
if you actually look at the APA, which
Yeah.
is the statute that talks about what is the job of a court in an administrative law case, the APA says that if the agency is not following statute, it's the court's job to get them into line. So the only evidence we have about what Congress wants courts to be doing is suggest that they should actually be engaged and they should be keeping agencies within their statutory authority.
At any rate, this is a very powerful statement by Judge Gorsuch. It's well worth your attention and reading through in full. He's done his homework.
Okay, that concludes the show. Thanks for listening. For more judicial engagement, be sure to follow Rob and Evan on Twitter. Their handles are @EvanBurnick and @FreeRangeLawyer. Until next time, this is John Ross from the Institute for Justice, pushing you to get engaged.